Good afternoon, everyone. His Lordship Justice Eric Ogola, His Lordship Justice Anthony Mrima, Her Ladyship Justice Dr. Frida Mugambi, on ruling petition E565 of 2024, regarding Gachagua versus State Law Office.
May it please you, my Lord. My name is Shadrach Moset, Solicitor General. Appearing together with Professor Gitu Muigai, Senior Counsel, that's for the Attorney General, Emmanuel Peter, Deputy Chief State Counsel, Charles Mutinda, Deputy Chief State Counsel. Then for the National Assembly, we have Elk Gumbo appearing for the National Assembly, and Paul Nyamodi, and the Honorable George Gitonga Murugara. My lords and my lady, for the Speaker of the National Assembly, we have Benson Milimo and Josephat Kunyoni appearing for the Speaker of the National Assembly. My lords and my lady, for the Senate, we have Professor Tom Ochenda and Moni Mukele Edwin. For the Speaker of the Senate, my lords, my lady, we have Mercy Tanchi and Peter Wanyama appearing for the Senate, for the Speaker of the Senate. And for interested parties, my lord, we have Moses Kipkoge, we have Dr. Mutomi Yonkoru, we have Kenny Meli, and we have Ponface Mwelelu and Eric Murioki appearing for Professor Kitule Kindiki. Sorry, my lord, for the Senate, we have Honorable Hirali Sigay for the Senate.
To Professor Tom Ochenda.
Yes, that is in addition, my lord, to Professor Tom Ochenda.
Hillary who?
Sigay. Honorable Hirali Sigay, Senate.
My lord, I'm present.
My lord, for the sixth respondent, Much obliged, my lord. I leave it at that.
My lord, for the sixth respondent, Dr. Kamodo, continue to appear at a protest.
And my colleagues, Mr. Muge for the Chandegua in petition number Nyaga, 5015.
Akibe, we consolidated and we came up with a new lineup of the party. So it may not be very appropriate to keep on referring to.
You take the notes, but I mean, some of it. The person who took the notes is not here.
That's okay.
Yeah.
We'll supply.
And I've not seen any order to indicate now that.
Okay.
So that I can know.
We will supply after the proceedings.
My lords, your leadership, Paul Mwite, I appear with Mr. Soanya, George Sekimpa, and Tom Macharia for the Deputy President of the Republic of Kenya in the consolidated petition and in any other petition where he is a party. Thank you.
My name is Hamini. I appear for Kutocha Syria. I think this is party in B565 of 2024 with my land friend, Mr. John, but I haven't seen him. That I should take it to. And then I also appear for myself. You understand? That's
My lady and my lords, for the third may it please you, my lady and my lords. My name is Nelson Harvey. I appear for the interested party of Kenya, together with my two colleagues, Hosea Manwa.
Jose and who?
Hosea Manwa, Kevin Mitchell,
Where's Kevin?
and
Maybe perhaps for guidance.
on which matters Ramon. Good afternoon. Was served with the office of the Deputy Registrar, stating that there were several matters that were mentioned this morning, this afternoon, and last evening we were breaking, but to come for a ruling. Perhaps you need to have clarity that we may not have.
We are dealing with the ruling, matter in which the ruling is supposed to be delivered now. After that, we'll give directions.
And if the is there for them, it means there are some acts of voting on record for forum who did not participate or they are not participating.
Like who?
Like Nelson Harvey.
Lord, lady, we have asked Double Zero to spend some little time with this newly with wife, but doesn't deplete the energy. In I appearing on the
Is there any other concern before we read the ruling? Our ruling is ready on the consolidated petitions, with the lead file being petition number E565. We have set out the structure of the ruling, but we'll begin from our analysis of the issues that we think are relevant for now. This is the ruling. Having carefully considered the pleadings, submissions, and evidence on record, we consider the following issues arising for determination. 1, what are the prevailing constitutional and statutory interpretation methods? 2, whether the Honorable the DCJ can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution. 3, other related matters. On the first issue, the Constitution is a document sui generis. It is the ground norm which legally commands superiority and dominance over any other laws, and its interpretation, as of necessity, must be in a manner that all other laws bow to. The court in S versus Atchison, 1991, captured the centrality of the Constitution as follows. The Constitution of a nation is not simply a statute which mechanically defines the structure of government and the relationship between the government and the governed. It is a mirror reflecting the national soul, the identification of ideals and aspirations of a nation, the articulation of the values bonding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. In the matter before the court, the High Court has once again been called upon to address the issue as to whether the Honorable the Deputy Chief Justice of the Republic of Kenya, whom we refer to herein as the DCJ, can exercise the power of assigning and empaneling expanded benches of the High Court. As such, the interlink between Articles 161 sub-Article 2 and Article 163 sub-Article 1 and Article 165 sub-Article 4 of the Constitution, as well as Section 5 of the Judicial Service Act, come into play. On that score, it is paramount to briefly look at how the Constitution and the statutes ought to be interpreted. As a starting point, the Constitution itself provides for its own theory of interpretation. That is in Article 20, sub-Article 4, and Article 259, sub-Article 1. Article 20, sub-Article 4 requires courts, while interpreting the Bill of Rights, to promote the values that underlie an open and democratic society based on human dignity, equality, equity, and freedom, and the spirit, purport, and the objects of the Bill of Rights. Article 259, sub-article 1, commands courts to interpret the Constitution in a manner that promotes its purposes, values, principles, advances, and rule of law. Human rights and fundamental freedoms in the Bill of Rights permits the development of the law and contributes to good governance. In hailing the Constitution of Kenya as a highly transformative one, courts have over time developed various methods or canons of interpretation. In the case of David Ndii and others versus Attorney General, the learned High Court judges dealt with 4 constitutional interpretive principles, being that the Constitution must be interpreted holistically, that the Constitution does not favor formalistic approaches to its interpretation, and it must not be interpreted as one would a mere statute. The Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, and that in interpreting the Constitution, non-legal considerations are important to give its true meaning and values. The Supreme Court, in the matter of the Kenya National Commission on Human Rights, Supreme Court advisory opinion reference, which I've given at paragraph 26, answered the question as to what holistic interpretation of the Constitution means. The court stated as follows: "But what is meant by holistic interpretation of the Constitution? It must mean interpreting the Constitution in context. It is contextual analysis of a constitutional provision, reading it alongside and against other provisions, so as to maintain a rational explication of what the Constitution must be taken to mean in the light of the history of the issues in dispute and of the prevailing circumstances." In the case of Tiny Fuza versus Attorney General, which I've given, the court was of the firm position that the Constitution must be read as an integrated whole. The court observed as follows: "The entire Constitution has to be read as an integrated whole, and no one particular provision destroying the other, but each sustaining the other. This is the rule of harmony, the rule of completeness and exhaustiveness, and the rule of paramountcy of the written Constitution." On the tenet that the Constitution does not favor formalistic approaches to its interpretation, and that it must not be interpreted as one would a mere statute, the Supreme Court pronounced itself in the case in Interim Independent Electoral Commission. The court said as follows: "The rules of constitutional interpretation do not favor formalistic or positivistic approaches. The Constitution has incorporated non-legal considerations which we must take into account in exercising our jurisdiction. The Constitution has a most modern Bill of Rights that envisions a human rights-based and social justice-oriented state and society. The values and principles articulated in the preamble, in Article 10, in Chapter 6, and in various provisions reflect historical, economic, social, cultural, and political realities and aspirations that are critical in building a robust, patriotic, and indigenous jurisprudence for Kenya. Article 159, sub-article 1 states that judicial authority is derived from the people. That authority must be reflected in the decisions made by the courts." Close quote. In expounding the principle that the Constitution has provided its own theory of interpretation to protect and preserve its values, objects, and purposes, the retired Chief Justice, His Lordship Honorable Mutunga, had the following to say in his concurring opinion in the Speaker of the Senate and another versus Attorney General. The Honorable Chief Justice then had this to say: "In both my respective dissenting and concurring opinions in the matter of principle of gender representation in the National Assembly and Senate, I argued that both the Constitution 2010 and the Supreme Court Act 2011 both provide comprehensive interpretive frameworks upon which fundamental hooks, pillars, and solid foundations for the interpretation of our Constitution shall be based. In both opinions, I provided the interpretive coordinates that should guide our jurisprudential journey as we identify the core provisions of our Constitution, understand its content, and determine its intended effect. He proceeded to say more, which I have included, but I will not read. The Supreme Court also expounded the incorporation of non-legal considerations and their importance in constitutional interpretation. In the case Communications Commission of Kenya and 5 others versus Rural Media Services, at paragraph 356, the court said this: we revisit once again the critical theory of constitutional interpretation and relate it to the emerging human rights jurisprudence based on Chapter 4, Bill of Rights of our Constitution. The fundamental right in question, in this case, the freedom and independence of the media. We have taken this opportunity to illustrate how historical, economic, social, cultural, and political content is fundamentally critical in discerning the various provisions of the Constitution that pronounce on its theory of interpretation. A brief narrative of historical, economic, social, cultural, and political backgrounds to Article 4, Sub-Article 2, Article 33, Article 34, and Article 35 of the Constitution has been given above in paragraphs 145 and 146. We begin with the concurring opinion of the CJ and the President in Gitirau Munya case, where there was references to Black Law Dictionary, where it was said that references to Black Law Dictionary will not, therefore, always be enough, and references to foreign cases will have to take into account these peculiar Kenyan needs and context. It is possible to set out the ingredients of the theory of the interpretation of the Constitution. The theory is derived from the Constitution through conceptions that my dissenting and concurring opinions have signaled as examples of interpretive coordinates. I'll not read the entire quotation. Then in the case of Center for Rights, Education and Awareness and another, the Court of Appeal also dealt with the subject of constitutional interpretation and laid out the very principles discussed above. The court further recounted the nexus between the principles of constitutional interpretation and the principle of statutory interpretation in the following manner. The principles on constitutional interpretation are not new. They also apply to the construction of statutes. There are other important principles which apply to the constructions of statutes, which, in my view, also apply to the construction of a constitution, such as presumption against absurdity, meaning that a court should avoid a construction that produces an absurd result. The presumption against unworkable or impracticable result, meaning that a court should find against a construction which produces unworkable or impracticable result. Presumption against an anomalous or illogical result, meaning that a court should find against a construction that creates an anomaly or otherwise produces an irrational or illogical result. And the presumption against artificial result, meaning that a court should find against a construction that produces artificial result. And lastly, the principle that the law should serve public interest, meaning that the court should strive to avoid adopting a construction which is in any way adverse to public interest, economic, social, and political, or otherwise. The court, as an independent arbiter of the Constitution, has fidelity to the Constitution and has to be guided by the letter and spirit of the Constitution. On our part, we wish to re-emphasize that the Constitution directs that it shall be interpreted in line with the doctrine of living constitutionalism. The doctrine holds that a constitution is a living document meant to evolve over time to reflect societal changes, contemporary realities, and shifting values. It further recognizes that the law is dynamic and adaptable to evolving circumstances, often encapsulated in the maxim that, in quote, the law is always speaking. It underscores the constitutional provisions as not static or frozen in time, but must be understood as applying to current circumstances regardless of their original context. This interpretive approach ensures that the Constitution remains relevant and effective in guiding the governance and legal framework of a modern, dynamic society. Moreover, the doctrine that the law is always speaking aligns with the purposive approach to constitutional interpretation as endorsed by courts in various jurisdictions. Under this approach, courts are required to interpret constitutional provisions in a way that gives effect to their underlying purpose and objectives, rather than adhering to a rigid or literal reading. Further, courts have emphasized the need for a flexible and forward-looking interpretation of the Constitution to meet the needs of a modern state. With the above interpretive principles in mind, we will now deal with other issues posed in the application under consideration.
I will deal with the second issue on whether the DCJ can assign judges pursuant to Article 165, Sub-Article 4 of the Constitution. There is no doubt that this was the most contested issue in the subject application. Article 165, Sub-Article 3 and Sub-Article 4 of the Constitution provide for empanelment of benches of an even number of judges as follows. Permit me not to go through that. In dealing with the above issue, courts have taken two diametrically opposite positions. One of them being that the assignment of judges is a constitutional duty which can only be undertaken by the Honorable Chief Justice. As such, the Honorable DCJ cannot assign judges under Article 165, Sub-Article 4 of the Constitution. The other position posits that although the duty to assign judges is provided for in the Constitution, its implementation is administrative, and that duty can be undertaken by the Honorable DCJ. In Kenya Medical Research Institute versus AG, which was a 3-judge bench of this court, held as follows. A quote, paragraph 37. Therefore, by empaneling this bench, the Chief Justice was carrying out his constitutional mandate as opposed to similar functions under the former Constitution, which were hinged on the constitutional provisions and were merely administrative. End of quote. In Leina, Conchela, and others, which was a 5-judge bench of this court, the court went ahead and described the role of the Chief Justice under Article 165.4 as constitutional as opposed to a merely administrative function. It also said, it is our view that a constitutional mandate of the CJ can be judicial, administrative, or political, and the current Constitution does not indeed set that the Chief Justice is the head of the judiciary which embodies all these functions. The learned judges that empaneled bench then found that the constitutional mandate exercised by the CJ under 165.4 of the Constitution is an administrative function. The court also elaborately dealt with the issue as to whether such an administrative function could be undertaken by the Honorable DCJ, and in the end, the court rendered itself as follows. The court, paragraph 78, it therefore our finding that constitutional function of the CJ to assign benches under Article 165.4, being an administrative function, can be performed by the Deputy Chief Justice when the Chief Justice is for good reason unable to perform. End of quote. The petitioners in these matters also cited the decision in Okoiti versus JSC and another, is constitutional petition number A408 of 2020, as buttressing the position that the assignment of judges is a constitutional mandate and the sole preserve of the Honorable the Chief Justice. The decision was delivered by yours truly, who is part of this expanded bench. We have carefully considered the said decision. One of the issues therein, which may be said to have a bearing on this matter, was whether the Honorable CJ would rely on Section 5, subsection 4, and subsection 5 of the Judicial Service Act to authorize the Honorable DCJ to serve as the acting Chief Justice when the Chief Justice was proceeding on leave pending retirement until when a succeeding Chief Justice was appointed. As the matter did not deal with the nitty-gritties of the aspect of assigning of judges, but rather the constitutionality of the actions of the CJA who was exiting service, we respectively find that the issue is not at par with what is under consideration in this instant application. The said decision is hence distinguishable. Returning to the matter at hand, it is imperative to look at the various terms which come to play in this matter, including the administrative actions as well as judicial actions. We have gone through that. I do not think there is need for me to read all that. It's in the ruling, and I proceed to state that from the above discourse, we do not find any difficulty in affirming the position that a constitutional mandate of the Honorable Chief Justice can be judicial, administrative, or political. We further find and hold that the constitutional mandate exercised by the Honorable Chief Justice under Article 165, sub-Article 4 of the Constitution, is a constitutionally administrative function. So now consider whether the function of the Honorable Chief Justice under 165, sub-Article 4 of the Constitution, can be performed by the Honorable DCJ. Article 161 of the Constitution establishes the office of the Chief Justice as the head of the judiciary, and that of the Deputy Chief Justice as the deputy head of the judiciary. Article 163 of the Constitution creates the Supreme Court and designates the Honorable Chief Justice as the president of the court. The Deputy Chief Justice is to deputize the Chief Justice and is also the Vice President of the court. Article 171 of the Constitution establishes the Judicial Service Commission, or the JC, as one of the Chapter 15 commissions. The Honorable Chief Justice in JC is the chairperson, and in this scenario, and unlike the constitutional architecture in Articles 161 and 163, the Honorable DCJ is not the vice chairperson of JSC. Running alongside the foregoing are the functions of the Chief Justice and the Honorable DCJ as provided for in Section 5 of the Judicial Service Act. The provision states as follows. This is in respect to administration of the judiciary. I do not need to read through all that. I proceed to say that the decision in Leina Conchela also dealt with the definitions and various types of deputies, and ultimately rendered itself in the following manner. I think this one I should quote. But paragraph 77, it says, it has been canvassed before us that where the Constitution intends the Deputy Chief Justice to act on behalf of the Chief Justice, it has expressly stated so. Specific examples cited were Articles 141.1, 144.4, 148.4. These provisions fall under Chapter 9 of the Constitution that deals with the executive. This chapter does not have a general provision as regards the deputization of the Chief Justice by the Deputy Chief Justice, as is provided for in Article 161 to be in Chapter 10 of the Constitution on the judiciary. Hence, the provision of the deputization of the Chief Justice in Chapter number 9. A holistic and purposeful interpretation of Article 161 2B of the Constitution and Section 5 of the Judicial Service Act leads us to the conclusion that the Deputy Chief Justice substitutes the Chief Justice where necessary, end of quote. In the end, the learned judges found and held that the constitutional function of the Honorable Chief Justice to assign the benches under Article 165 of the Constitution, being an administrative function, can be performed by the DCJ when the DCJ is, for good reason, unable to perform this function. On our part, we have carefully addressed our minds to the issue. We find that there was a deliberate scheme by the drafters of the Constitution for the Honorable DCJ to deputize the Honorable CJ as Deputy Head of the Judiciary and as the Vice President of the Supreme Court, but not in the JSC. Such was an emphasis on the various manifestations of the constitutional duties bestowed upon the Honorable Chief Justice and the Honorable DCJ. As such, the prevailing legal position is that the Honorable DCJ can deputize the Honorable CJ in discharging judicial functions and in the administration of the judiciary as an arm of government, but cannot do so in respect of the affairs of the JSC. Our attention has also been drawn to the provisions of Article 259, Sub-Article 3B of the Constitution, which states as follows. This refers to construing the Constitution, and Sub-Article 3 provides as follows. Every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore, among other things, B, any reference in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing the functions of the office at any particular time. Emphasis, or otherwise performing the functions of the office at any particular time. The above provision creates three tiers in which constitutional functions can be exercised. That is, by the substantive office holder, or by a person in an acting capacity, or by a person otherwise performing the functions of the office at any particular time. In our understanding, and against the background of the doctrine as stated, the drafters of our Constitution were deliberate about ensuring that the administration of duties and the application of the constitutional provisions are continuous and seamless, recognizing the necessity for offices and their functions to be performed even in transitional or extraordinary circumstances. Such an interpretation avoids technicalities and vacuums that could disrupt the functioning of state officers or public institutions, thereby promoting administrative efficiency and upholding the principles of constitutional governance. The provision reflects the broader principles of the rule of law and good governance, which require that state and public officers continue to function effectively, even during periods of transition or when the substantive office holder is unavailable. It in turn promotes legal certainty and administrative efficiency by ensuring that all constitutional responsibilities are carried out without disruption. For this reason, the functions of Article 165, Sub-Article 4, in our view, and in as far as the same relate to the office of the Chief Justice, also includes the Deputy Chief Justice acting in the capacity of the office of the Chief Justice or discharging its functions in an interim, acting or auxiliary role. At this point in time, we also wish to point out that the Honorable Chief Justice empaneled this very bench on the 14th day of October 2024 to deal with 6 constitutional petitions that inter alia challenged the first petitioner's impeachment process in the National Assembly. The said petitions are still current. On the 18th of October 2024, the Honorable DCJ empaneled the same bench to deal with constitutional petitions challenging the impeachment of the first petitioner in the Senate. To us, It is beyond peradventure that the Honorable DCJ can assign judges under Article 165, Article 4 of the Constitution, whenever he or she is discharging any of the constitutional functions on behalf of the Chief Justice. In this case, we do not find any fault in the Honorable DCJ assigning judges to sit in this bench, more so when the Honorable Chief Justice has not raised any red flag. Thank you.
Right up during the submissions on the application. Besides the issue of the benches and panelment by the Deputy CJ, several additional issues have been raised. The bench found it necessary to address these issues so as to ensure both the completeness of the record and finality in the issue raised. During the submissions, an issue was raised concerning the directions issued by the three-judge bench and the transmission of the files in Nairobi Petition E565 of 2024, Kerugoya Petition E013014 consolidated, as well as E015 of 2024. A review of the CTS, that is a case tracking system, confirms that the petition in E565 of 2024 was filed on the 18th of October 2024 at 8:00 a.m. Later that same day, approximately 5 hours on, at 1:51 p.m., Justice Chacha Muita dealt with an application filed under certificate of urgency, which had been submitted alongside the petition. By 5:33 p.m., roughly 3 hours after the earlier application, a notice of motion application dated the 1st of October 2024 was dated the 1st of October 2024 was filed, this time by the respondents, the following orders. 1, that the application be certified as urgent and service of the application be dispensed with in the first instance. 2, that pending the hearing and determination of that application, inter partes, this honorable court be set aside, vary, or review the orders issued on the 18th day of October 2024, that is the interim conservatory orders. 3, that in the alternative, this court be set aside, vary, or discharge the ex parte orders issued on the day of October 2024, and 4, that this honorable court do any other orders it did in the interest of justice. Following its empanelment on the 18th of October 2024, having received directions from the Office of the Deputy CJ, the bench deliberated on the appropriate directions. On the 19th of October 2024, at 12:20 p.m., the bench issued the following directions. That in light of the urgency of the matter, the weighty raised therein, we direct that the application be served and responded to forthwith for hearing inter partes on Tuesday, the 22nd of October 2024 at 11 a.m. in court number 8. Petition E013, on the other hand, was filed on the 25th of September 2024 at 8:30 p.m., while petition E014 filed on the 2nd of October 20 at 7:07 p.m., both way past official working hours. CTS will further show that an application in E014 was filed on the 30th of September 2024, and directions were issued the very same day, though the matter was not certified as urgent. Subsequent directions, the ruling on the 11th of October 2024 resulted in the consolidation of petition E013, E014, followed by an order for M. As the record on CTS will further show, the directions issued by the court in 14 of 2020 2024, which were issued the 2nd of October 2024, were again issued at 6 p.m., which is outside of what one would call the routine working hours of the court. This was due to the urgency demonstrated in the application, which sought directions regarding the then ongoing process. The bench takes great exception to the petitioner applicant's conduct that when favorable to them, issues of orders issued outside of what one would refer to as normal working hours of the court no concern. However, when the court acts in instance where it has been by any other party, likewise proceed with an application and the applicants their in. Moving to petition E015, the CPS again would show that the same was filed on the 8th of October 2024. Once again, following the directions issued by the court, this bench was empaneled on October 24. Here are all the three, that is E565 of 2024, E013, all of 2024. From this sequence of events, it is notable that the interaction between counsel and the courts on an almost real-time basis is not novel, and is in fact a practice that counsel are well familiar with. ETS enables both counsel and the court to operate in real time, transcending traditional time limits. This fact also buttresses the argument that with the advent of the CS system, it is not unusual for courts directions within the filing of an application or outside of what once again would be referred to outside the routine work hours of the court where circumstances require. Moreover, in raising the issue of impropriety, the applicants omitted a crucial fact, which was that the court had been by the respondents petitions E565 of 4 15 of 2024. As such, the court did not convene suo motu, but rather in response to the application for it. The applicants have repeatedly referred to this convening as a sit of the court, a term that we feel as a bench requires clarification and demystification. It is a matter of judicial notice that since the onset of the COVID-19 pandemic and the introduction of the case tracking system, the tradition of dealing with certificates of urgency has since evolved. Allow me to quote the practice direction number 19A of the High Court Practice Directions of the 11th of January 2020. States as follows: that applications filed under certificate of urgency shall be considered by the judge, emphasize here, at the earliest opportunity. While the practice direction also stipulated that applications filed after 12 p.m. may be considered the next working day, the full adoption of the e-filing system across the judiciary has largely rendered this provision obsolete. Applications are now processed almost in real time, a fact well known to the justice users across the country and which we have demonstrated in this ruling. Furthermore, practice direction 19B confers discretion upon the court to issue orders or directions without the attendance of advocates or parties. This implies that the court can indeed issue directions on an application without the need for a formal. The relevant provision, once again, reads as follows: that the court may, in its discretion, issue orders, stroke directions without the attendance of the advocates or parties. I end quote. In this court, rather in this case, the issue has been raised that this court allegedly sat and considered an application by the respondent on a Saturday outside of the official court hours. The ordinary definition of a sitting, as provided in the Black's Law Dictionary, is a formal occasion when the court convenes to conduct its business. In this instance, no such formal sitting occurred. In this instance, may I repeat, no such formal sitting occurred. Rather, the bench merely conferred and issued directions electronically as expressly permitted under Practice Directions 19B. This is markedly different from a court session in which the bench is convened to hear and determine a matter. Furthermore, no evidence or proceedings have been presented before this bench to support the claim that a formal sitting did take place. Accordingly, it is only fair and reasonable for the parties to dispel any notion that this bench convened to hear arguments from any party ex parte before issuing directions. No such formal sitting took place, the court again emphasizes, and directions were issued electronically in line with established practice and procedural rules. We do, however, recommend that the current practice directions and relevant statutes, such as the High Court Organization and Administration Act, be amended so as to provide a much needed further clarity on this subject. Moreover, for the avoidance of doubts, and out of all the prayers sought by the respondent, only prayer number 1, which sought to have the matter certified as urgent, was granted. No other reliefs were considered or granted at the time. It is evident that the court was fully cognizant of both the urgency of the matter and the potential repercussions that granting any further ex parte orders could have had on the prevailing status quo. With this understanding, and in an effort to balance the scales of justice, the bench issued the directions that are now being challenged. We hold the view that there was nothing unconventional in the manner in which this bench dealt with the 2 applications filed under certificate of urgency. As regards the argument that directions had already been issued by the respective courts for a mention before the bench on the 24th of October 2024, the arguments by the applicants appear to insinuate that the bench ought to have retained the date. For clarity purposes, this date had not been given by this bench. Rather, this date had been given prior to the empanelment of this bench. However, upon empanelment of the bench, the applications under certificate of urgency, the ones that I have just referred to, were filed, which applications were dealt with, and we feel rightly so. Being seized of the matter, it is our view that the bench retains the discretion to issue appropriate directions depending on the developments and in light of its mandate, as it did, having been moved by a party under certificate of urgency. With respect to the claim that was raised on discriminatory transmission of files to the bench, it must be emphasized that this bench has no role and no control whatsoever in the administrative processes that occur prior to its empanelment. Concerns have been raised about delays in the transmission of certain files, but it is crucial for us to clarify that the term transmission in this case may not necessarily refer to the physical transfer of documents. In the context of judicial processes, particularly with the advent of digital systems, transmission may very well refer to the electronic movement or assignment of case files within the judiciary's digital infrastructure. We say this on the strength of the fact that with the CTS, all filed documents are available in real time across the judiciary, eliminating the need for physical file movement. Let me refer once again to practice direction number 41A Roman 2, which provides that advocates and litigants shall have access to court information electronically. While this court cannot and will not speculate on the causes of any delays in file transmission, the bench nonetheless finds no basis for concluding that such delays amount to any form of procedural omission on the part of the bench, as no such evidence has been presented. The applicants have equally in their submissions attempted to cast aspersions on the proceedings of this court, some of which I have already referenced. That is that the court was convened on a Saturday, stating that there is no urgency in this matter, and so there was no need to convene the sittings of the 22nd day of October 2024, that this matter is being given priority over other petitions which have been filed, an insinuation that the bench is part of a conspiracy to infringe the petitioner's Article 50 right to fair hearing, and what I have again alluded to, that the transmission of the files from the Kirugoya High Court took place with what has been referred to as a supersonic speed. One of the counsels went further by intimating that an exercise akin to the radical surgery may well be forthcoming, a statement which the bench, with tremendous respect, perceives as a veiled attempt at intimidation. The bench feels that such remarks are regrettable and wholly inappropriate. This bench remains firm in its duty and will not be swayed or influenced by any form of intimidation, regardless of its source. The bench takes the view that the applicants appear to selectively focus on aspects that favor their position while conveniently disregarding that the clients that the applicants are presently benefiting from final conservatory orders, which this bench did not deem it fit to lift. Despite having obtained final conservatory orders, as the court has already observed, it is now apparent that the applicants no longer perceive the urgency in this matter. Instead, they seek to cast aspersions on this court for addressing the matter with the necessary expedition. Such conduct is contradictory and undermines the very urgency that the applicants had initially invoked. The bench notes that the issues raised in this petition have on various occasions and before different judges consistently been certified as urgent and as involving substantive constitutional questions. This underscores the gravity and significance of the matters at hand. One of the counsels again insinuated that this bench is part of a conspiracy to violate the petitioner's right to a fair hearing under Article 50 of the Constitution. The bench finds that these submissions are without any foundation and wholly without merit. This court has not issued any rulings or directions that would suggest such an intention. It is apparent that this argument was made for the sake of the gallery, and we find it unnecessary to therefore address it further, save to reaffirm that this court remains fully committed to upholding the Constitution and the rule of law. In conclusion, we do find and hold that the accusations made by the applicants against this bench are entirely without merit. On this limb, the last part of the limb is whether the matter raises issues of public interest which require expeditious disposition of the petitions. The applicants have urged that the applications before the court are not urgent and have loudly wondered why it was necessary to give directions for hearing of the applications on the 22nd day of October 2024. In response, the bench quotes Article 131, which establishes the office of the President and the office of the Deputy President, and also we have cited Article 147 with regards to the functions of the Deputy President, just to lay context. And the context is this, according to the bench, that the first petitioner has been impeached under Article 145 of the Constitution, marking the first instance of such an event in Kenya's history. The impeachment of the said petitioner has undoubtedly garnered significant public interest, and these court proceedings represent a direct challenge to that impeachment. It goes without saying that these legal proceedings are of paramount concern to the citizens of this country. To suggest, as the applicants have, that this matter lacks urgency and does not warrant prompt adjudication is disingenuous and dismissive of its far-reaching implications. We have taken the liberty to define the term public interest in the Black's Law Dictionary, and you will also find the Supreme Court of Kenya's definition of public interest in the case of Stune versus Roscoe, which permit me not to get into. Safe to say that from the foregoing, a matter is of public interest if the holding on law affects a considerable number of people in society, if the holding in law involves government and or government agencies, if a determination of law affects the proper functioning of public institutions of governance or of the court's scope for dispensing redress, and if the holding of law affects the mode of discharge of duty by public officers. These proceedings, in our view, as the bench, raise enormous public interest, and it is in the interest of that public that these proceedings are heard and finalized most expeditiously. Therefore, the aspersions cast by the applicants concerning the directions for the hearing of the applications before the court on the 22nd day of October 2024, in our view, lack basis, and they are. I thank you.
This position, having carefully considered the application, we are satisfied that the prayers sought herein must fail. Nonetheless, as indicated in our ruling, there is a pressing need for a clear practice directions regarding the procedure and the process for handling virtual and online directions and proceedings. We commend the applicants, as this application has illuminated the necessity for such guidelines and made the issue more apparent. As such, we hereby direct the Honorable Deputy Registrar of this division to transmit a copy of this ruling to the Honorable Chief Justice. Before we conclude, the bench wishes to once again emphasize its unwavering commitment to objective neutrality in this matter. We assure all parties that their right to a fair hearing remains fully safeguarded. The bench, acting in fidelity to its oath of office and in strict adherence to the dictates of the Constitution, remains resolutely committed to the fair and just determination of the issues before it. Finally, the application dated 22nd of October 2024 is disallowed with costs in the course. Leave to appeal is hereby granted. Certified copies of these proceedings and rulings shall be availed upon payment of the requisite court fees as the case may be. That's the ruling of the court.
I replied, my lord.
My Lord, on behalf of the petitioners, we have listened to the ruling. We have got no problem with the feasibility of it one way or the other. We leave it to our clients, the decision on whether or not they will appeal the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never. That as it may, I believe since we received some communications from the Deputy Registrar, and there were certain other pending matters in the files that were under consideration, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether this is as Milimani Senior on Rapomwicha has anything to add.
My lords, your ladyship, we appreciate this honorable court for his own volition has granted leave to appeal. Speaking for myself, obviously the decision is that of the client. So I will be advising the client. It is for the client to make a decision. But in fairness to me as counsel, another counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this. It is damaging to counsel. That is an issue that definitely needs to be taken out of the record of this by the court of appeal. It was a very unfair accusation.
May it please the court, on behalf of the respondents, we thank you for the timely nature of the delivery of that ruling to allow this matter to proceed. We note that you have permitted the parties leave to appeal, and we support that. Respondents support a fair resolution of this dispute in accordance with the law. Therefore, we would not oppose their right to appeal. Having said that, however, and in reference to my learned friend, Mr. Kibe Mungai, who has alluded to other petitions pending before, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by your clerk or your legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give directions on any other matter that may be before you or may be anticipated to come before you. We thank you.
My lords, my lady, on behalf of the National Assembly, I wish to express our gratitude for the very clear ruling that the court has delivered this afternoon. The ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday to deal with. My lords, my lady, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. And just to put it on record, my lord, that we are ready to proceed with that application this afternoon. Members of the court will recall that last week on Tuesday, on the 15th of this month, at an hour not very different to this, when it suited the petitioners to have their application for conservatory orders heard, they insisted on it being heard. And we request that the urgency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to immediately after this. I'm most obliged.
My lords and your ladyship, further to that, for Senate, I wish to state, my lords and your ladyship, that unlike the petitioners, we are willing to argue the application in a record 30 minutes.
Is it the same application?
Yes, the application dated 18th October 2024. We will only ask for 30 minutes to exhaust our application. We will dive straight into constitutional principles. We will not take much time. The respondents can have as much time as they want so that this matter can be concluded. My lords, Mr. Kibe has talked about the gallery of Paul Mwite Senior Counsel. From that side, it was apparent that they were not just addressing the court. They were addressing other matters.
Do we need to
Let us not go into that.
I will engage in arguments on that.
Let us not go into that now.
I will withdraw that. Yes. But my lord, we are ready to proceed. 30 minutes.
No, we don't want you to raise something and then you say you withdraw it. After causing the damage.
Okay, my lord.
We withdraw properly.
It's okay, my lord. My lord, I will withdraw the remark that the petitioners are addressing the public gallery today. Most of them.
My lords, with your permission, yesterday we were barred from being part of this proceedings. We have seen communication that now legally here have stopped the morning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before it.
In which petition?
Files,
in which petition?
There is petition 5 E570, E550, E541, E572. Supposed to be before. But complaint to the CJ in the morning, and the CJ has directed we appear here and be part of this mosaic. Let us be part of it.
Your Lordship, equally, I raise hearing E549 and associate myself with the submissions made by my learned senior counsel, Paul Mwite, and the ones made by my learned friend, Senior Kibe. Your Lordship, the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday I indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated. And we have been issued the notice that my friend Mr. Omar is referring to, that he also sees of 4 other matters: E570, E550, E541, and E570. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice so that the court may refer the same. Subsequent to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We would wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which, Your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My Lord, may please interrupt, but this is most untrue. We are all counsel of some reasonable experience. We all appreciate some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship, very
My Lord, if I may, my Lord. Yes. There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
Yeah, your lordship.
Okay, you have talked enough.
Counsel on this side,
Yes.
counsel on that side appears to be taking the whole of it.
Because they stand much.
Please.
Just speak, Mr. Mute. If you want to be heard, just speak. We'll listen.
My Lord, I'm asking
Yes.
for equity of power.
We
tying counsel on this side.
they stand and speak. You also just stand and speak. We have no situation. Yes, speak.
My Lord, I think for purposes of clarity, yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling in red, the question that they wanted was the application for the validity plus the issue to do with the recusal be heard together. The understanding of the court ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending, I think, actually, I know about 3 applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned colleague is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about somebody is trying to delay this matter. We are the victim. And I reiterate that. For purposes of the petitions before you, we would like this petition heard as of yesterday. And we kept on saying yesterday, the petitions to be heard. My lord, these rules, because it's the enforcement of the constitutions, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent, so that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number one. Issue number two, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Miss Kimoto, yes. They were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situation where some of the advocates in the four matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My lord, I beg you to have the information of that.
Your Lordship, I had just wanted to highlight the content of the notice which you received.
I think we'll talk about the notice. Just sit down. We want to talk about that notice.
Your Lordship,
I will talk about that notice before you speak.
My Lord, your permission to address the
And even if the court wants to talk, you don't want the court to talk. Dr. Camino, let me address the issue of the notice.
Sorry, I apologize.
Yes.
I apologize.
I think we have made it very clear in the ruling which I have just delivered that the matters before this court are very important to the people of this republic. And you will appreciate that petitions are still being filed throughout Kenya. When we retired yesterday, we received several empanelment of matters of which we gave this notice. Therefore, don't think you are the only person who are in these petitions. There are also other Kenyans who are coming day in, night out. So the matters which you've set out for mention are the matters in which we have been empaneled as from yesterday. So you wait for court to give directions, then you start talking. You cannot just start talking from the air without facts. Let us mention these files first. Then from there, you'll see the directions emerging, and then you can make your prayers. Let's mention these files first. Okay. The other clarification is that we have two cohorts of petitions which have been consolidated. The first cohort were the petitions which were filed to challenge the processes both in parliament, yes. And during that time, this bench consolidated 6 petitions, with the lead petition being 522 of 2024. Is that correct? That petition, number 522 of 2024, is the lead file in the petitions which were filed before the finalization of the matters in the Senate. Then, after the proceedings in the Senate, other petitions were filed. And with running parallel petitions before the Senate proceedings and after the Senate proceedings. You will remember that petition number 522 was, we listed it for a mention on 29th of this month. But because of need to know, because I know there could be cross-cutting representation in these petitions, we decided just to call it because we knew that all of you would be here, so that if there's anything you want to say on those petitions, you can say it. So that's the reason why we have petition 522 here for a mention. There's nothing to be mentioned, but we said since parties are likely to be here, and some of the parties were even asking for it yesterday, so we brought it. But the other petitions to be mentioned are specific petitions where we have been empaneled. And we wanted to find out the way forward, whether we can consolidate these petitions or whether they can be done separately. So these are petitions number, let's mention petition number 570 of 2024, AD by Guru and Victor Gatia. Yes, this petition. Yes. Excuse me. Just a minute. Yes.
Hello, Jack. In this petition, this one was filed by the law firm of Philip Mutembei, and
we are a nation in pursuit. We pursue just about everything you could imagine. Not only wealth and relationships